Director General, National Institute for Legislative and Democratic Studies, Prof Abubakar Sulaiman, has emphasized the need for consistency and clarity in the interpretation of court judgments across Nigeria's judicial system. Prof Sulaiman made the call during a one-day public dialogue on judicial reforms held in Abuja. He noted that in legal systems governed by precedent, consistency in judicial interpretation is fundamental to ensuring judicial integrity and public confidence in the courts.
We aim to explore the causes, consequences, and potential resolution of such divergent interpretation. This dialogue, therefore, will lead us to some pertinent questions, such as, are the divergent court judgments a product of judicial creativity or doctrinal confusion? Do they signify a healthy pluralism in legal thought, or do they undermine the coherence of our legal system? I am of the firm belief and opinion that with the quality of persons seated here today, both as keynote speakers and discussants, I'm confident that answers shall be provided to these pertinent questions.
He reaffirmed the Institute's role as a leading research and policy institution supporting legislative development in Nigeria and thanked participants for honoring the invitation to the dialogue. Legal scholars, judges, lawmakers, and policy experts interrogated the growing concerns around conflicting judicial interpretations in the country.
Justice Amina Augie of the Supreme Court once remarked, "It is not every judge that can afford regular law reports. Without access to precedent, even the best trained judge will walk blindfolded through jurisprudential landmines. Moreover, there is no precedent monitoring institution or case law harmonization body akin to the Judicial College in the UK or the Federal Judicial Center in the US.
The Federal High Court CJ, because of the number of pre-election matters coming up, said, look, the easiest way to solve this come by way of originating summons. So practice directions were issued by the Federal High Court, asking litigants, if you want to contest, file originating summons. Now, the Supreme Court, in several cases, in fact, up to 2021, reiterated the rule that if a process is wrongly filed by way of originating summons when it should be a complaint, the order to make is not one of striking out, but to ask them to file pleadings. That's the Supreme Court. But in this instance, what Justice Nweze said was, because the matter was filed by way of originating summons, that was wrong. And accordingly, the suit was incompetent and dismissed it.